Hello everyone, I'm George from Ireland. So I'm looking here at criminal law, at offences against the person in particular, but crimes in general, and various defences to these crimes. Well, how could you do something which would be a crime but is held not to be a crime because of extenuating circumstances? So what defences will succeed in court? I'm looking in particular at self-defence and duress, that you did something that would have been illegal, but because it was in self-defence, it's lawful, or you did it under duress and therefore it's lawful. All right, so at common law, self-defence includes defence of property, such as R against Hussey, having to use force to stop somebody burning down your house or stealing your car or whatever, or defence of another. Okay, so I wasn't being attacked, I saw her being attacked, so I had to go to her rescue and use force against other people, in which case I wouldn't be guilty of any crime. That's in R against Gladstone-Williams. So statute also provides for this. Section 6 of the Criminal Law Act 1967 says a person may use such force as is reasonable in the circumstances in the prevention of crime, or in effecting or assisting the lawful arrest of offenders or suspected offenders, or of persons unlawfully at large. Remember, I asked some police officers about this. Does citizens' arrest exist? They said yes, it does, but it's got to be something reasonably serious. It can't be you suspect somebody of dropping litter, and you've got to call the police as soon as possible. Otherwise, it could be false imprisonment, and not to use any more force than you really need to use. Let me see. I mean, the police, they've issued letters to shopkeepers in the United Kingdom saying, supposing you have to seize a shoplifter till the police officer arrives, make sure you respect that person's human rights and don't go too far. Okay, don't kick them or punch them or whatever, or throttle them. So you'd be better off not risking it, because otherwise you'd be done for assault. So there are other statutes about it, like the Criminal Justice and Immigration Act 2008. In section 76 thereof, it says that it goes further than the Criminal Law Act, which it approves of, but it says the question arises whether the degree of force used by the defendant against the person victim was reasonable in the circumstances. So I recall reading police officer named Tony Long, his memoirs describing dealing with the Brixton riots in about 1982, when police officers there in Brixton, London, they've got no shields. A mob is at the far end of the streets, lobbing bits of brick at the police officer, being hit, ow, 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 hurting them. So the police officers found some stones and bricks and started throwing them back. And one of the senior police officers saying to the constable, "You can't do that." He said, "Well, I can do what is reasonable in the situation to defend myself. We don't have a shield to stop myself being hit. We don't have helmets. You know, if we had guns, if we shot them and killed them, that might be seen as too much. But how are we going to stop them lobbing bricks? Say, stop, that's not working. We could baton charge them. Well, that might work, but that's more force. You might be hit on the way. But throwing bricks back to discourage them, to scatter them, that dissuaded them from carrying on their assault, so probably held to be reasonable under the circumstances. Certainly wasn't charged in relation to it, even though it's photographed lobbing a brick, and because of the number on his shoulder, they could tell which police officer it was. Okay, self-defence can be private defence or section 6 public defence. There's a trigger and response. The trigger causes someone to need to use force. All right. So there's got to be a sufficient reason, not just I saw someone and I think he's a thief. No. And the response must be the amount of force used. It can't be grossly disproportionate. So it's got to be defending yourself from physical attack, not from simply defending your peace of mind, as was held in R against Bulletin. So what's the trigger here? Is a subjective test, not an objective test. Did the defendant believe it was necessary to use force? If he's right, then that's sound defence. If he's wrong, but he honestly believed it, that defence will still work. If he's wrong, but he didn't actually believe it, then there's no defence. So the belief can turn out to be mistaken, but could still be a valid defence, as in Gladstone-Williams. However, the defendant cannot rely on his having been in a crapulous state at the time to excuse his mistake. If he got drunk, he believed that he needed to use force, but that false belief was induced through his voluntary intoxication. That defence clause doesn't work, as is found against R against Hatton. So preemptive strike is permitted. As one judge said, that we can't weigh force exactly if there's an uplifted knife. So someone's raising their hand to hit me, so then I quickly get in and get him before he gets me. That's Devlin against Armstrong and R against Beckford about this. Again, you're not obliged to retreat. You're in a dangerous situation. You could go to safety, but no, I'm going to stand my ground and fight. Then that's permissible. As in R against Bird, and is provided by section 76.6a of the Act. So the defendant cannot invoke this defence of self-defence if he's the aggressor. That was found in R against Forrester. Okay, so you burgle someone's house, the householder says, "Oh, right, I'm going to get you," and starts hitting you, and then you hit back and severely injured the householder. No, that's not self-defence. You cause the whole situation in the first place. Okay, so the response, well, there was a change initiated by the Criminal Justice and Immigration Act of 2008. In Section 76, it said that they've got to tell apart two different situations: householder situations and non-householder situations. What a householder case, that's as per Section 76, 8A. In this case, the defence of self-defence is invoked by the householder. The householder is using this force whilst he's in a building, not necessarily his house, just by the word householder. The defendant, therefore, is not a trespasser. It's his house or his office or whatever, and the defendant believes that the victim is in the building as a trespasser, doesn't have permission to be there, doesn't work there. So the building is a dwelling. It doesn't have to be the place where the defendant himself lives. It could be his friend's house, could be his relative's house. Okay, so there was some doubt about what a building is. How about if it's a flat above your shop or something that you own? And is that a householder case? Well, yes, it is. So the whole building can be a dwelling, even if you're not in the actual residential part of it, as provided by Section 6, 8b. So then the non-householder cases, we have to ask whether the degree of force utilised was reasonable. This is an objective test, okay, not an objective test, not what the person themselves believe, but what would a reasonable man in like circumstances believe, and therefore the court shall judge it according to the facts. Okay, so there was R against Owino is a case about this. So he uses force. Let's say he's wrong, he uses too much force. That's a mistake. But that still might be considered reasonable. R against Owino again. However, if his misjudgment is consequent upon voluntarily getting himself into a crapulous state through alcohol, through illegal drugs, through unnecessary medicine, then that defence won't work. So let's look at the response then in non-householder cases. So Section 76.7a says, a person acting for a legitimate purpose may not be able to weigh to a nicety the exact measure of necessary action. Close quotation. So here you are defending the property, and then you use more force than you needed to. We have to be forgiving of these people because in the heat of the moment, they're panicked, it's highly emotive, they've got to make a split-second judgment. Necessarily, they're going to get it wrong sometimes, and they can't be microscopically accurate about the level of violence that was necessary to defend themselves. They punched a bit harder than they needed to. They punched more times than they should have. But they'd rather overdo it than underdo it than allow their assailant to overpower them. This is found in Palmer against R, Reed against Wasti, and the Attorney General's for Northern Ireland's reference, number 1 of 1975. Okay, so more about non-householder cases. Section 76.7b says, the evidence of a person's having only done what a person honestly and instinctively thought was necessary for a legitimate purpose constitutes strong evidence that only reasonable action was taken by that person for the purpose. Close quotation. So R against Palmer is about that. So the force used is unreasonable if it's grossly disproportionate. That was the expression used in the Act, grossly disproportionate. It can be somewhat disproportionate, still reasonable, but if it's very disproportionate, not reasonable. So R on the application of Denby Collins against the Secretary of State for Justice is a case about that. Now, the judge was Sir Brian Leveson, and he said that the force must be of a reasonable level, but the householder might be regarded as having acted reasonably if the force used was not too disproportionate. It can be a bit disproportionate, that's still reasonable, but if it's way over the top, no, that's not reasonable, doesn't have a defence. So, duress is another defence. That means forced into something, a threat, a physical threat to beat you up, to kill you, or to someone else is going to be severely beaten up or killed. There's also duress of circumstance, which will come on to that. R against Graham. In this case, the defendant committed a crime because he believed he had been threatened. These are credible threats. If he didn't commit a crime, he thought that he would be killed or suffer grievous bodily harm. So what would a sober person of an ordinary level of courage with the same characteristics the defendant have thought? Because we've got to think about gender, men usually bigger, a bit tougher than women. I hope I'm not being prejudiced there. Person of that height, of how bulky are you, how muscular, what's your age? If you're a 25-year-old man, pretty physically fit, what if you're a 95-year-old man, less able to defend yourself? What if you're, a 30-year-old woman is probably stronger than a 70-year-old woman, things like that. Children are more susceptible to these threats. What if you're very weak because your medical condition, can't fight, can't run away? So we have to make allowances for people who are less able to defend themselves or to scarper. So the House of Lords in R against Hassan approved the R against Graham test for whether this duress should be allowed to operate as a defence. We have to ask whether the defendant had any other course open to him. What was he going to be able to escape? Would be able to fight back? If he couldn't take evasive action, then the defence will probably work. So R against Hassan is about defence by threat. The threat is going to be that you're going to be killed or suffer serious harm. It can't be something trifling, can't be just a slap. Okay, so the threat has to be made against the defendant, a member of his family, or a close friend. It can't be against a random member of the public, someone whom the defendant would regard himself as being responsible for. We have to think about what D thought about the threat, how credible he believed it was. Now, this is going to be assessed objectively. His belief that the threat was real must be reasonable, and a reasonable person would have done the same thing as a defendant. Put yourself in his shoes. What would you have done in that situation, assuming you were the same sort of age, gender, and the same physique as him? Because if you're a heavyweight boxing champion or someone with special forces training, you'd be more able to defend yourself than an ordinary person. If you're a real scaredy cat, well, we're not going to be doing too many allowances for that. Now, you might have some sort of death wish and stand up to any threat. Well, we're not going to judge the defendant by that standard. So the conduct that was we're trying to excuse, supposed to excuse because of this duress, must have been the thing that was actually caused by the threat. You can't say, well, I kidnapped someone because I was threatened, but the person threatened me only told me to supply cannabis. Well, wait a second, your threat didn't cause you to kidnap someone, it might have caused you to supply cannabis. So the threat has got to be causing you to commit that offence that you're using this as a defence for. And there must have been no other alternative open to the defendant, as he couldn't run away, he couldn't get police protection, and so on. So this defence won't work if the defendant has laid himself open to these threats. And defensive duress does not work for murder or attempted murder. It can work for any other crime, though. So anyway, it's up to if the defence raise this claim of duress, then the burden of proof shifts to the prosecution to show that it's false. But if the prosecution can demonstrate that even one element of it's false, then that defence collapses. So if they prove that the defence wasn't credible, or that the defendant didn't believe in it, or that the threat wasn't against a defendant or a relative or a close friend, then it is not going to work. If they can prove that the defendant could easily have got away from this threat, then the defence shan't work. If the prosecution can show that the defendant laid himself open to it, the defence won't operate, or that the defendant was just being too cowardly, an ordinary person would have stood up to such a threat, then the defence shan't work, or that there was no serious violence threatened, anything like that, then this defence shan't operate. Okay, so duress by threat, as I say, it must be that you're going to be killed or badly wounded. Defence to property won't work, as was found in DPP Northern Ireland against Lynch. Okay, that I'm going to vandalise your bicycle or break up your garden shed. No, it's got to be threat against a human being. It cannot be against an animal. So R against Shayla is a case about this, not about the animal part of this. So these things are judged objectively, not subjectively. So did the threat cause real fear? Would a reasonable person have thought that the threat was realistic? And would a reasonable person have responded in the same way as the defendant if the reasonable person was of the same sex, age, and build as that person? So anyway, this is we have to think about any recognised psychological conditions. R against Bowen is is about this, or Abbott against R. We have to think of proportionality. The level of violence that was threatened and the severity of the crime that was then committed. So this is a concession to human frailty. So was the crime that the defendant committed, was it really caused by the threat or not? Would the defendant have committed it anyway, in which case the defence won't work? So there has to be a strong connection between the threat made and the crime committed. R and Cole is against that. Now, what if a few threats existed, but not all of them were of heavy violence? That's R against Valderrama at Vega is about that. Then it's difficult to say. So what if, yes, there was a real threat, but the defendant could easily have got away or could have got police protection? Then the defence won't work, as in R against Hudson and Taylor, R against Hassan. So Lord Bingham held in that last case, if it is not such as he reasonably expects to follow immediately or almost immediately on his failure to comply with the threat, there may be little or no room for doubt that he could have taken evasive action, whether by going to the police or in some other way to avoid committing a crime. Close quotation. Like a lot of these banged up abroad cases, see people going to the Caribbean and then the gangsters get them. You've got to take drugs and pack them on them and you can't escape, and driven to the airport and there's no chance to turn around. They're watching you get on the plane. Okay, so what if you have a chance to take evasive action? R against Abdul Hussein. Well, Lord Justice Rose said, if Anne Frank had stolen a car to escape from Amsterdam and had been charged with theft, the tenets of English law would not, in our judgment, have denied the defence of duress on the grounds that she would have waited for the Gestapo's knock on the door. Close quotation. So in order to save your life, then yes, you can commit a crime. Not murder, though. So what if you've joined a gang and you're committing some crimes to them of your free will, then they threaten you to commit a greater crime than you really wanted to? Will this defence work? Well, no. R and Sharp, R against Shepard, R and Hassan are all about these. So Lord Bingham said here, the defence of duress is excluded when, as a result of the accused's voluntary association with others engaged in criminal activity, he foresaw or ought to have reasonably foreseen the risk of being subject to any compulsion by threats of violence. Close quotation. Otherwise, gangsters could so often get away with it. You chose to be a felon, you associated with felonious company, and you happily took part in burglaries and bank robberies and drug dealing, but then you didn't like carrying out this false imprisonment, and they said, well, we're going to knock your lights out if you don't. No, you can't get away with it, because you've signed up for many crimes, and yes, you can be pressured into doing something you don't really want to do. R against Ali is a bit like this. So Attorney General for Northern Ireland against Lynch is a case where, this defence won't work for murder. Now, Lynch, he was only a driver for an IRA hit squad when they went to murder. I think it was some member of the Ulster Defence Regiment. And no, he didn't pull the trigger, but nevertheless he was guilty of murder because he was an accessory, right? He had abetted this crime. So although I'm not sure they must have threatened to kill him, but that didn't work because he still participated in murder. R against Howe is a similar case. R against Gotts, this duress won't work for attempted murder either. So we're looking at duress of circumstances. There's R against Willer, R against Conway, R against Martin. So the elements of this are the same as the elements defined of duress, except instead of the threat, we see that the need to commit a crime because otherwise you're going to die. R against Abdul Hussein is a case like that. There's also defence of necessity. Is it the lesser of two evils? There's Lee against Gladstone or Pipe against DPP, London Borough against Williams. Or there was some guys escaped from prison and claimed that they were forced to because it was the circumstance and the prison was so dreadful. Well, that defence didn't work. Well, there's that famous case, I can't remember it, of those sailors adrift on some lifeboat in the 19th century. 3 of them, and the 2 stronger ones killed and ate the littlest one because they had no food for weeks. They were caught, and they said that with defence of necessity, but that didn't work. So R against Dudley and Stevens is an example, or RA, conjoined twins. This operation where one of the twins was going to die. So that's just a whistle-stop tour through some of the defences that are available for committing various things, doing various things which would otherwise be crimes. But the defence operates, you're not guilty. Toodaloo.